So should we start?
Yeah.
Dear participants, I would like to extend a very warm welcome to all of you for joining us for this session of the African Institute of International Law Webinar Series. As you may all know, the webinar series are a platform to discuss AU and international law issues relating to the African continent. Today's session is very practical in nature. Throughout the continent, there are various people who either aspire to a career in international law, or who, having started a career, may wish to strengthen their profile and expand their horizon. So it is for this reason that today we have decided to take advantage of the experience and generosity of two distinguished international law scholars and practitioners from Africa, namely Professor Phoebe Okowa and Professor Makane Mbengue. To be fair with all of you, I could introduce them very, very briefly and in a very personal manner, because these were two people, two elders, who have, at least for me, who have really been mentoring me, taking the time, discussing with me issues when I was still considering, when I'm still having my career in international law. So I met Makane probably in 25 when I was still an LLM candidate in Geneva, and my sister Phoebe in 2013 in a conference on environmental law. So, but in this context, today I would like to be a little bit more formal and introduce them as follows. So Phoebe Okowa is a professor of public international law at Queen Mary University of London and an advocate of the High Court of Kenya. She is educated at the University of Nairobi and the University of Oxford, and has previously taught at the University of Bristol and held visiting appointment at the University of Lille and Stockholm. In 2011 and 2015, she was global visiting professor at New York University School of Law, a member of the Permanent Court of Arbitration at The Hague. She has appeared as counsel before the International Court of Justice and lectured on practical questions of international law for the United Nations at its regional course on international law for Africa. She has written on a wide range of contemporary international law topics, including the interface between state responsibility and international crimes, Africa and the International Criminal Court, unilateral and collective responses to the protection of natural resources in conflict zone, and aspect of the protection of the environment. She's Kenya's nominee for the ILC for the term of 2023 and 2027. As far as my brother Makane, Professor Makane Mbengue is concerned, he's a professor of international law at the law faculty of the University of Geneva and director of the Department of International Law and International Organization. He is also an affiliate professor at Sciences Po Paris School of Law and a member of the Curatorium of the Hague Academy of International Law. He is also an associate member of the Institute of International Law, and we have to congratulate him since he got elected a month ago. He has acted as counsel and arbitrator in dispute settlement before international courts and tribunals, and as advisor for several international organizations, including the AU. He is the author of several publications in the field of general international law, international environmental law, international economic law, and since 2017, is the president of the African Society of International Law. I'm really, really, really happy and thrilled to have both of them here, and for the fact that they accepted to make time from their busy schedule to engage with us in this conversation. As far as the structure of the conversation is concerned, we will start first by a statement from Professor Makane Mbengue, and then we will follow up with another statement from Phoebe, And that would be followed by question and answer. The topic of this first statement would be, for Makane, what does a career in international law look like? And that would be, for Phoebe, it will be, what can you do to prepare for such a career in international law? After the Q&A sessions, then we will hear from both of them on their tips to build a career in international law. So without further ado, I will call on Makane to take the floor and tell us, what does a career in international law look like, except traveling a lot?
Thank you very much, my dear brother Mamadou. Thank you very much to the African Institute of International Law for the invitation, and in particular to EDEFE and you, Mamadou, for the invitation. And thank you so much for this very kind introduction. It's of course a great pleasure for me to be here, not only to see you, but also to share this conversation with my very dear colleague and sister, Professor Phoebe Okowa. So you have asked me to share some few views on what career of international lawyer look like, and of course, you know, I want to start by saying that you can have different answers to that, because I think that at the end of the day, it's all based on the experiences of people to whom you would ask such a question. And of course, what I'm sharing here is more of my personal experience of how I see the career in international law, the career of an international lawyer. In my view, we can usually make the distinction between different hats that one can wear when engaging in a career in international law. And I would like to put those hats into two generic or broader categories. So on one side, I would say that you have what we call the practitioner hats, and on the other side, you have what I would call the academic hats. So let me start with the practitioner hats. I think that when one look at the career of an international lawyer, you can identify five main practitioner hats in the process of such a career. The first one is acting as an advisor. Acting as an advisor. I insist very much on the word advisor, and I want to make the distinction between acting as an advisor and acting as a counsel. I will come back to that later. Acting as an advisor in our field means that you are not engaged in advocacy, but you are trying to tailor international law to the needs of the actors who would contact you to benefit from your advice. So one very important aspect of the career as an international lawyer is to act as an advisor. And there I would like to make the distinction, if you allow me, between acting as an advisor for governments and acting as an advisor for international organizations. We know that usually in the international system, the two main subjects, the two main actors are on one side states and on the other side international organizations. And then of course, when you act as an advisor in the process of your career as an international lawyer, most of the time you might be called to either advise governments or advise international organizations. What does advising government consist in? I think it consists of two main things. First, governments, they usually approach international lawyers to get advice on how they can better participate in international lawmaking. So this is one aspect of the job, of the career as an international lawyer, is that governments might quite often approach you, but to get, you know, advice, guidance on how to better participate in international lawmaking. I've been, for instance, involved several times in helping some governments in Africa on shaping, formulating what they call their economic diplomacy. So basically, what strategies, what options should they think about when engaging in economic diplomacy, negotiating economic treaties, trade treaties, investment treaties, etc. So this is one part of the job as an advisor for governments, that they are expecting you in an objective manner. That's why I say that advising is not about advocacy. It's really they're expecting that on an objective manner, you would advise them on how to better participate in international lawmaking. But of course, that advice has to be adapted to the specificity of that country, to the needs of that country. A second aspect that I've found very interesting when it comes to advise governments is advising them on the implementation of international law. Quite often, governments are also interested on advice on how to implement international law, how to implement human rights treaties, how to implement environmental treaties, how to implement trade treaties, etc. And one activity at my level that I've been very much engaged in too is advising governments, for instance, on adopting model bilateral investment strategies, where governments want to know, what are the best approach to implement international investment law in their countries, and in order to attract, of course, foreign investment. So this is one aspect that I found very interesting when working for governments as an advisor. But what does it mean? It means that advising governments is really about advising them, taking into account their specific interest. The country with which you are working, you need to take the very specific interest of that country. So even if your advice is not about advocacy, even if it is supposed to be objective, you are expected in that framework, in that frame, you are expected to tailor what you are advising to the specific need of the country for which you are working. And then, as I mentioned, you have also the whole work as an advisor for international organizations. There, you are not, of course, when you work for an international organization, you cannot just take into account the specific interest of a country. That is the difficulty, is that when you advise international organizations, you need to take into account, the broad majority or the broad membership, or if not even the entire membership of the international organization. So of course, it makes the advice a bit more sensitive, it makes the advice more difficult, but this is something that as international lawyers, I think is important to keep in mind, is that advising a government is not the same than advising international organization. And usually international organizations, they would ask for advice with respect to two aspects. First, interpretation of their constitutions. You know that international organizations, they are not primary subjects of international law, they are derived subjects of international law. So what does it mean? It means that they can only act within the limits of their functions, within the limits of their competencies. So international organizations are always, concerned with, okay, what can I do? And quite often they would of course, have recourse to lawyers that would help them with some advice on how to interpret their constitutive acts. I remember.
Sorry for this. Ambassador Sani, can you switch off your microphone?
Thank you very much, Ambassador. No, so I was saying one aspect, of course, would be to advise them on how to interpret their constitutive acts. And I remember, Mamadou, one of my very first tasks as an advisor of an international organization, it was about 20 years or 21 years ago, when I was involved in advising the International Labour Organization on how to interpret Article 33 of the ILO Constitution, because remember, it was the time when Myanmar was engaged into forced labor. And then there was the whole question on whether the ILO could actually impose sanctions against one of its member states. So that was a very interesting task. Another thing that international organizations are very interested in when it comes to advising them is to advising them on actions or policies that they want to undertake. You know that international organizations, they don't only engage in implementing international law or interpreting their constitution, but also they engage in operational activities, in operational tasks. And of course, they need sometimes advice on that, on how to better orientate certain policies or actions they want to take. And once again, in relation to ILO, I remember that few years ago, you had that crisis within the ILO where you had a battle between the representatives, you know, of the employers and the representatives of the employees that were disagreeing on whether the right to strike is part of customary international law. And this has totally paralyzed the organization. And the ILO was wondering whether it should request an advisory opinion to the International Court of Justice, whether it should go into that task of going to the International Court of Justice and request an advisory opinion, and what would it mean for an international organization like the ILO to bring an advisory opinion before the International Court of Justice? What would it mean in terms of formulating the question, et cetera, et cetera? So this is another aspect that is different from interpretation of the Constitutive Act. So this is what I wanted to say about the work as an advisor, which is a very important part of the career in international law. A second practitioner hat, on which I'm not going to be long because it's quite known in our field, is of course to act as counsel in international litigation. As counsel in international litigation, I'm sure Professor Okowa will jump back on that. But as you know, we are living in a judicialized era of international law. We have more and more disputes. The expansion of international law has led to more disputes among states. And one very important aspect of the current job, it was not always like that. It was not always like that back in the days. But I would say that in the last 15 years, at least with the boom, the baby boom of investment arbitration, we've been witnessing more and more international lawyers being engaged, as counsels in international litigation. And of course, as counsel, what does it mean? A counsel means that you are doing advocacy. It's not the same job. It means you are there, you come with some subjective aspects, elements, strategies in order to satisfy the needs of your clients. And we can come back to the discussion. But of course, we need to make a distinction between counseling governments in international litigation, counseling international organizations in international litigation, and counseling individuals, individuals in international litigation, because we have many fields of international law where individuals are the complaining parties in human rights, in the human rights field, for instance, but even in investment arbitration, most of the time it is a private investor that initiates a case against a government. And so we can come back to that during the discussion, but there are, of course, differences in what does it mean to counsel those different actors in international litigation. But counsel in international litigation is a very important part of our job nowadays. A third hat, on which also I'm not going to be long, but which is very important also nowadays, is the adjudicator hat. The adjudicator hat, more and more, we international lawyers, we are called to act as adjudicators. We are not permanent judges at the International Court of Justice. We are not necessarily permanent judges at the International Tribunal for the Law of the Sea, etc. But we are more and more called to act, for instance, as arbitrators. Many of us have been appointed or will be appointed in the future by a party to a dispute to act as arbitrator. This is also something that has become, that is a new facet of the career in international law. 20 years ago, 25 years ago, 30 years ago, it was very rare, you would count the number of people in our business who would sit as arbitrator or adjudicator. But now this has become very, very common in our field for us to be called to act as adjudicator. And what does it mean? It means that as an adjudicator, you need to put aside your strong views of international law. When you act as an adjudicator, forget about what you have written in books, forget about what you have written in articles, forget about the school to which you belong. You are there to serve the good administration of international justice. So you are there to be neutral, independent, impartial, even if it is hard to be, I think, absolutely independent from your ideas. But this is the task you are called to do, taking distance and try to solve a dispute between parties. And we can come back to that in the discussion. A fourth practitioner hat that has become very important in our field, in the career of international law, is to act as negotiator, in particular in the African continent. In the African continent, in the last 10 years, more and more international lawyers that are not connected to governments at all have been called to help governments with negotiations. And of course, negotiation, you need to make the distinction when the government appoints you as a negotiator, as such. So you are in the team of a government to negotiate for that government, meaning you are there to represent the interest of that government in the negotiations. But then there is another way for us to be involved in negotiations, is that we are involved in negotiation to facilitate negotiations. Because you have governments that are negotiating about, boundaries, or they are negotiating about how to manage international shared international water resources, and they need somebody as an expert. But you are not an expert, you are there as a negotiator, but the negotiator that is facilitating the negotiations and help them in how to draft, maybe an agreement, etc. It is different from you acting as a negotiator of a government itself. It's a different task, but it's not about advising. It's not about, there are some elements of advising, but it's not about advising. You are there more as a sort of facilitator that would give and bring solutions to the parties in order to have a positive outcome to their negotiation. And we can come back, of course, to that, because I know my time is limited. Last but not least, Mamadou, as a practitioner, had that something that I think is also very important is to act as consultant or expert. Here also, I like to distinguish being an advisor and being a consultant or an expert. It's not the same job. In being an advisor means you are advising to tailor and in order to tailor your advice to the needs, for instance, of a government. When you act as a consultant and expert, you are actually closer to the academic life. When you are engaged, in particular by international organizations, but even by governments, to act as consultant and expert. What do they want? They want you to actually tell them what is the international law, but this has to be, evidence-based, evidence-based on research. They want to know, okay, what is the state of international environmental law in this field? Or, what is the state of investment law in this field? Or what does the law of the sea say about this? They don't want you to tailor anything to their needs. They want you to tell them this is what's going on. And one example I have of my personal experience is when I work as consultant for the UN Secretary General. I was one of the 3 consultants that have actually assisted the UN Secretary General on its report on gaps in international environmental law. But that was purely evidence-based research. It was about us showing in different fields of international law what's going on, where are the gaps, where are the non-gaps, and that's it. So this is what the work as consultant and expert is about. It's not about tailoring to the needs. Then, of course, sometimes you can be involved as expert in international litigation. And there, it's true that behind the scene, when you work as expert in international litigation, the party that is approaching you will of course try to tell you, can you please help me? Can you please help me on how to present the expertise, you know, to an investment tribunal, for instance, but expertise that is going in the direction of what the party that is appointing you as an expert would like the tribunal to understand. So it is something that is there, but most of the time, working as consultant, as expert, is something that is very, it's about practice, but very close to academic way of life. And now just to finish, Mamadou, quickly on the academic arts, but this I will go very fast, and we can come back to that in the discussion. But of course, for the academic arts hats, there are three hats that I think are very important in our career. First of all, of course, teaching. The teaching of international law is one very important aspect of the career in international law, you know, in particular in parts of the world like Africa, where the dissemination of international law is very important, where the understanding of international law is very important, where we still need to train new generations of international lawyers. Well, there the teaching is a very important aspect of the career that should not be underestimated, where we should actually even think about new fields, new ideas on what to teach. And then another important aspect of the academic hat, research. Research is very important, and it's a very important part of the career. You have many people who spend most of their life in their career, most of their career as international lawyers, doing research. Think about institutions like the Max Planck Institute in Luxembourg or the Max Planck Institute in Heidelberg. It's all about research. It's about people who make research and who contribute to the development of international law, who contribute on an everyday basis to the work even of practitioners, of judges, of adjudicators, of advisors, etc., because they are the ones who are actually, you know, taking time to look at everything and build the puzzle. So very important aspect of the work of the career that on which I can come back in the discussion. And last but not least, of course, very important aspect of the academic hat, participation in conferences. Now, participation in conferences, you know, I think this is a very exciting part of the career. Why it's a very exciting part of the career is because not only it allows you to go and share your views, share your ideas with colleagues, but I think it most importantly, it allows you to be part of a network. It allows you to be part of a network. I always like to say that a career in international law, and I'm sure that Professor Okowa will come back on that, is a career where, you know, networking is very important. Being part of networks is very important, and participating, you know, to the conferences in Africa, European society, American society, and so on. They help you to be part of a network. They help you to be part of this club, this family of international law that can then facilitate, of course, more access to the different sides of this career. But I will stop here, Mamadou, just in conclusion to say that, of course, I don't see these two hats, the academic hats and the practitioner hats, as being mutually exclusive. They complement each other. And I think the best career in international law is to be able to enjoy both, you know, both the practitioner hat and the academic hat, because they complement each other. They are mutually supportive. And thank you again very much for the attention. Thank you.
Thank you so much, Makane, for this great overview and very insightful overview on the different hats that we can be wearing, and especially by concluding by the fact that we may need to wear them all at the same time. So I will now move on to my sister, Professor Phoebe Okowa. Phoebe has been asked to talk to us about what can you do to prepare for a career in international law. I noticed that this is the question that actually is coming up frequently in the chat. So I think that now you have your response. And Phoebe, we are listening to you. Welcome again. Yeah. Microphone. Phoebe, microphone.
Okay. Can you hear me now?
Great.
I would first like to take this opportunity to thank the African Institute of International Law for the invitation, and a special thank to you, Mamadou and Edefe, for organizing this, and for the honor, really. And of course, we joke that as a candidate, more publicity is good, any platform, but that's not the reason. I think this is a very important conversation that we ought to have, partly because we have a lot of lawyers, women lawyers, domestic lawyers, but there's a paucity of international lawyers, actually, operating within the international law field from Africa. I'm sure this is a conversation we can have. And as a candidate now, I have been particularly struck by just how many female international lawyers I've been able to engage with, hardly any, in terms of at the higher levels of practicing international law. So I think we have a responsibility to try and support and nurture the next generation who might want to pursue careers in international law, and at least say what those options are. How do you go about building a career, which is a question that keeps coming up in the chat room. Now, I have spent most of my life as a professional academic, mostly teaching, with occasional advisory work for governments and occasional work as counsel, advising, including domestic lawyers involved in litigation on questions of international law. And so the first question is, of course, it takes a lot of experience, trust to get to where Professor Makane is, where governments can entrust you with your maritime boundary dispute or some complex case. It's not going to happen overnight. And in a way, most of the questions we get in the chat, younger brothers and sisters who just want to know, what's the roadmap? How do I get there? And so I perhaps would start by telling a story that I was born and educated in Kenya. I went to university with every intention of being a professional lawyer, and law fascinated me, all aspects of it, company law, family law, constitutional law. But as time went on towards the final year, I was more and more gravitating towards either constitutional law or public international law. I suppose that was because I was very interested in how law could be used to tame public power, to hold political power accountable. And there's a context here. I grew up in a one-party state. The great conversation throughout my university days was how to stop the state from being repressive, to have much more space for human rights, for political participation, for democratic participation. And there was very little space within Kenya at that stage because it was a one-party state. So we were constantly drawing on international norms, drawing on international institutions to agitate for domestic reform. And so that's how I gravitated towards international law. It was fascinating. There was all this body of law, of treaties, which could actually hold the mighty state accountable. I had the incredible good luck of being taught international law by a very committed international lawyer who, Dr. Bonaya Adigodana, those of you who worked on international water law would know him. And his goal was just to nurture anyone who was interested in international law. So I was very supported in my dream to want to be an international lawyer. So the next step, of course, having done a whole broad range of subjects, which I imagine a number of our listeners are probably just in that position, is if you've now done your law degree and you qualified as a lawyer, but you really want to do international law, what should you do next? How do you get there? And the next thing I would say is go and do a postgraduate degree and start doing your research in what universities offer postgraduate degrees. What are their reputations? Which are the good ones for international law? What areas of international law interest you? Are you interested in international human rights law? Are you interested in international environmental law? Are you interested in international investment law? And really, in the age of the internet, just sit down and have a metrics of what universities interest you, what areas of funding they have. This can also be institutions within Africa or elsewhere. But the first thing is have all this information at hand. The next thing I would say is look at the profile of various professors teaching in these universities and really have a very honest discussion with yourself. What interests you? What do you really want to do? If you have further questions, I would say fire an email to a professor in an institution, but be sure that your email is very clear, crisp, well-written, and the information you're requesting. Most academics will actually respond to queries of that kind. So having done your homework, I've skipped one thing really. To be a good international lawyer, you first and foremost need to be a good lawyer. So try and just, either if you're already a lawyer, keep on honing on those skills. The key skills that will help you are the writing skills, be able to tell a story, be able to write well and effectively, even better if you can do it in more than one language. So, and this is something to work on. Read a lot, read about the area that you're interested in. There's nothing as frustrating as getting a misinformed email from a student who tells me, and I say this in my capacity, having acted as Director of Graduate Studies, Professor Okowa, I want to do a master's in this area, and they don't even know what subjects we offer, whether we have expertise in those areas. Don't say you want to come to Queen Mary to work on international economic law if there's no one teaching international economic law. Just do your homework. It's quite basic, because chances are you won't get a response. So I think having done that, or if you already have a master's and you really want to take things a stage further, you may want to do a PhD. And again, I know I'm talking to an audience where in most cases, for most of us, we have been able to do graduate work or postgraduate work on the basis of external funding, on the basis of getting a scholarship. So if you're doing a master's, do your research. Some of them would require you to have a statement, write a very clear, thoughtful statement on why you want to do a master's program in that institution. There's always a personal statement. Don't do it in a weekend. You know, if you're planning, actually take 2 or 3 months writing it and share it around so that it's a very clear, you know, there are still funding opportunities. I say this because sometimes we are unable to fund students because we didn't get good applicants. Now, the same goes for if you've decided that you want to do a PhD, because the truth is all careers in international law, at least a significant amount of them, very few people are able to make meaningful careers in international law without a postgraduate degree. So it's either a master's. If you've done a master's, you need to do a PhD. Same goes to the PhD. Again, have a clear proposal, a very thoughtful proposal. Some institutions would even have scholarships reserved for students from the Global South. I mean, I know the Hausa Law program tries to have an international program. The 10 Hausa scholars are global scholars. They're from all different regions. So find out about the program, who's there. And, you know, I don't know, email Professor Philip Olson if you're interested in human rights and just tell him you're interested in the program. It doesn't mean necessarily that you'll work with him, but these are all ways of, in a competitive world, getting people to take you seriously. You have to do the homework. You have to do the legwork. Last year, I had a student write to me a week before the deadlines for our graduate scholarships closed, one asking me for a reference, and 3 days before sending me a proposal, which was half-baked. I did email them afterwards, but you know, I say to them, that's an unfundable proposal. No one's going to fund it. So take your time. Let's talk about applying next year. So if you're thinking of doing a PhD, don't wake up one weekend or in 1 week. Really think carefully about what you want to work on your PhD on. It's complex, it's a lonely business, and it has to be credible and fundable. No institution now, not anymore, would take you on the chance that you'll develop your PhD proposal once you're in the institution. But there's help around. If you email people with ideas, clear ideas, it may take a few more than one email, but you will get the support to produce that coherent proposal. And quite frankly, we're talking 6 months as a minimum. Work on it, share it with your friends. Put yourself forward to present these ideas at conferences or write pro forma papers, have a roadmap, a primer as it were. Because essentially, in all the pathways that Professor Makane talked about, they will require a very deep understanding of international law. You need to understand international law as a system. So it doesn't matter if you're going to be an investment lawyer, you will still need to know the methodology of international law, the techniques, the processes of lawmaking. And to be honest, if you already have your master's, even if you already have your PhD, go back and hone those skills. When a case is thrown at you, They won't give you a case that specifically just requires your narrow expertise on a human rights question or an investment dispute. They will require you to bring to the table and to deploy all the skills you may have. There may be a question of a reservation of a treaty, a question of an intervention, methodology. Many questions and disputes within international law involve questions of whether or not the matter is governed by a given rule of international law or not. So the first thing I would say is always make sure that you're always the most knowledgeable person in the room. And if you're not, you know exactly how to find where the rules are. So hone your skills on the techniques, on methodology, on the processes of lawmaking in international law. So if X in your foreign ministry rings and says, I think we should make a reservation to this treaty, well, ask yourself, is it possible? What's the law on reservations? So it doesn't matter if your general expertise normally is investment, you still need to know the sources of international law and how they relate to each other. So I think I would say there's certain general skills. First, be a good lawyer, hone your writing skills, get a postgraduate degree, doesn't matter where, and even better in a good institution. If you want to do a PhD, very good idea, but do a PhD from a point of view of conviction. It's something you really want to do, that you'd be prepared to commit to it, but there is help there and there is funding. I know it's quite easy to be disillusioned and to say it's so much difficult. There are funding. I have acted in my own institution as director for graduate studies, and we've struggled to find from the pool of applicants an applicant that we ought to fund. In some cases, not funded at all. So I know now that there is funding there, but you just have to be that one person whose proposal stands out, whose proposal is fundable. But that takes work. That takes a lot of work. I think I'm going to stop unless this, I mean, the other things which you already know about internships, and how to apply for those, look for internship. But again, no one wants an intern who is not going to be useful to the organization. All these internships are very competitive. When you write your covering letter, most professional international lawyers, academic or working in an organization will be able to tell in 5 minutes whether they should really screen your application or not. How do you come across? Do you write well? Do you write effectively? Are you clear about why you want to be there? Do you have a track record of reliability and, you know, delivering, and all these questions? Are you professional? Are you culturally sensitive? And these are all skills we can acquire. After all, we're in some sense products of our environment, but then we are not wedded to it. You can overcome it, you can adapt. So much more general, this general skills, of working to being a good lawyer. If you are able to try and get a second language and be effective at it, those are selling skills in a competitive environment. But I think I'm going to stop, and I'd probably find it easier to respond to specific questions.
Phoebe, thank you very much. Thank you very much for this very down-to-earth advice, in the sense that getting a postgraduate degree, honing your skills, your drafting skills, your presentation skills, and not being a specialist, but rather being a generalist, because reality comes at you as it is, not as you are qualified. So you have to have the ability to navigate across various topics and various fields. So now we got a few questions. I want to take them really by a number of issues. We'll start first by briefly discussing language. What are the language requirements in order to be a very good international lawyer? Because you mentioned, Phoebe, in your conversation, to speak more than one language, but what are the, I would say, the working language of international law? What are the language requirements an international lawyer should be targeting? And how would you balance between drafting skills and oral expression skills? So how do you balance between the two? What is sought after in the job market? So let's start first with Makane, but then we will change the role. I give you the time to breathe. Makane.
Okay, thank you very
Let's
much.
make it short and very concise so that we can pick up on
for the question.
Yeah.
I would say that, you know, there is a fact of life today in the international law career or the international law business, is that English has become the language of
Both of us are rather francophone.
I know. And it's hard for a francophone like me to admit that, but I think I'm insisting on that in particular to send that message to all our francophone brothers and sisters here. You know, the reality is that if you want to be competitive, if you want to have access to the great internships that Professor Okowa was talking about, have access to certain circles in international law, you need to have a good command of English. Of course, nobody is expecting you as a non-Anglophone to be perfect in writing English or even in speaking it, but you should be able to engage with the other colleagues in the language of Shakespeare. So this is a fact of life. Then, of course, if you have some other languages, you know, like French, if you have a good command of English, and then you are good in French, you are good in Spanish, it's good because, you know, many countries in the world are Spanish speaking. You have a lot, for instance, of international litigation or international law advice that is you know, based on Spanish. So it's good to know Spanish. It's very good also to know French because we have still many countries that are speaking French. And in a field, for instance, Mamadou, that you know very well, like litigation before the International Court of Justice or litigation before the International Tribunal for the Law of the Sea, in those fields, for instance, it is actually useful. It is even an advantage to have French, because quite often governments which bring cases before those tribunals, those international courts, they need to have, you know, among their delegation, among their counsels and advocates, one or two of them who speak French, because you need to make sure that you can also, you know, connect with those judges that are not Anglophones, that are not of a common law culture. So it's actually good to have French or Spanish with you, but the starting point, I would say, in terms of language in the business today is English. And most of the international law, most of the publications are in English also. So if you want to educate yourself, if you want to be a strong international lawyer, like Professor Okowa was saying, you need to read a lot of the literature, which is mostly written in English. And you have some tribunals which do not even render, you know, decisions in another language than English. Just think about exit tribunals. Most of the investment case law is actually in English. So I would say English is the starting point. Thank you.
Okay, and now let me address the same question, but slightly twisted, to Phoebe. Phoebe, is there any relevance for French? Really, should we be, if I was a native English speaker, should I really strive to master French because I want to be an international lawyer?
Well, for the reasons Makane said, I have to say that I'm slightly embarrassed that I'm largely monolingual. I have coffee break French. In a world that speaks English, yeah. I tend to engage with the world on English terms, and that can be culturally quite insensitive. Remember, it's not just your skills as a lawyer. You'll be dealing with countries who have legal advisors, politicians, and all. So not to have those cultural sensitivities can actually also be professional suicide. It's not just a question of what's the language of the tribunal. You know, how do you engage with people? How do you come across? Do you understand what the world looks like in Ouagadougou? It's very different to what the world looks like when you're in Nairobi. And, you know, if I turn up in Ouagadougou with a very monolingual English perspective, it may not go down well. So as a practical matter, there's that as well. I also think that some of the yes, you can function, but the international court always has to have, I agree that the predominance of English is now unchallenged. But in many practical contexts as well, there's still a need for French. Also, partly, as you know, within the ICJ, there's always a requirement, and the Francophone countries are not anytime soon going to surrender the preeminence of French as another UN language in the business of international organizations. The other thing is just a question of, there are still a lot of really good literature which are in French. So in a sense, if you having a second language also just means you'll be a better lawyer. You'll have a perspective of what civil lawyers think. You'll be able to access the practice of civil lawyers. If you think about it, some of the great books, including Godana's actually, or Christina Marek on identity and continuity of states, were able to draw on the practice of other states. Okay. If you're going to write on accountability in international criminal law and you want to write about what's going on in DRC, it's a handicap to operate in only one language. So in one sense, you know, if you're in London or Nairobi, you may think that English is the only way to communicate with the world and the rest of the world should come and meet you. But actually, it's not true. In many parts of the world, the lingua franca is still just that. And the practice and the aspirations of those states matter, but they matter in their own language. So I would still say that no, if you're monolingual, try and be bilingual and invest in it, and try and learn a second language. Even if you don't perfect it, even if your language of business is English, it does help because we operate in a global world. And as I say, cultural sensitivities also matter. Understanding the political context in which international law operates also matters. And you cannot only understand them on your own terms, in your own language.
Yeah. Okay, let me now move to the second question. And this one may look provocative. Is international law a practice just in the West? Or am I, as a young international lawyer in Africa, able to think about career options in Africa itself? Is it possible to build a career in international law in Africa? So what are the opportunities that you see? Because all three of us are in the West, but is it possible to, what is your experience? How would you advise? I see in the chat that many of the participants are based in Africa. How do they do if they want to build their career in Africa and not to have to come to Europe? Yeah. So should I continue with you, Phoebe?
Sure.
And then pick up Makane.
So this is interesting in a sense because some of my advisory work has been for states in Africa, I won't say, and the legal departments of those, you know, they settle disputes on the basis of international law. So it's important. There are the legal departments and they are staffed with lawyers. I think they need to hone their skills on questions of international law, or foreign office ministries. You know, in a sense, if you're going to be employed as a lawyer in a Ministry of Foreign Affairs, and let's face it, all African states have ministries of foreign affairs. They all operate either in Geneva or sometimes at home in New York. They need to know international law and they need to understand it. They need to be able to comment on the drafts produced by the International Law Commission. They need to be able to comment at a high level on drafts produced by the Human Rights Council. And in a way, that's the only way as a continent that we'll also maintain our influence so that our practices are reflected in what those bodies do. So my starting point is I think universities need to teach international law and teach it seriously. I would even go further if I had my way. By the way, this is a battle I've even fought in my own institution here, that no one needs to graduate from a law school without studying international law or a legal subject that has some international element. In an increasingly globalized world, you cannot just operate on the basis of a knowledge of only of your substantive law rules. So most domestic lawyers in Kenya, for instance, would need to know international law, the impact of international law on domestic treaty regimes. They have foreign men, so they are already practicing international law. They just need to do it at a higher level and take it seriously. The opportunities for practicing international law, at least in foreign ministries, for domestic lawyers, they have to implement treaties in domestic law. Questions of immunity, questions of implementation rise before domestic courts. So in that sense, it's already there. Maybe they just don't think about it because it's not taken seriously. So the first point to say is, yes, you can practice international law. In fact, many of the opportunities are practically the same, whether it's academia, foreign ministry work, or within the offices of the Attorney General. And I think that's where most international lawyers practice international law anyway, whether it's in the Netherlands or here. You know, to practice at a high level like my brother, Professor Makane, is exceptional. There are only few international lawyers who practice before international tribunals or international courts. But that in itself is another question. That the reason why we don't have those lawyers is a question which only our own governments can answer, why they hire foreign lawyers, even in situations where they could hire domestic lawyers or other African international lawyers. But that's a different conversation for another day.
Yeah. Okay, Makane, I will come to you with the same question, but from a different angle. How critical is it for us to have very, very good international lawyer in the African continent? How critical is it?
What do you mean by how critical?
How vital? I will say something which will probably I should not say. Yes. Because last week I was reviewing the treaties of investment treaties concluded by Burkina Faso, and I was interested in their territorial clauses. And I found in some of those treaties that Burkina Faso had maritime areas. So that's a problem if you know that Burkina Faso is a landlocked country. So that's really where I'm trying to take you to. So how vital is it?
Something like that. on purpose. No, but thank you so much, Mamadou. You know, I just wanted to say quickly that I totally agree with Phoebe that we need to strengthen, we need to consolidate the teaching and the passion for international law in our universities in Africa. You know, I think that the reason why a lot of young Africans are not aware of the potential in international law, it's because in many of the law schools there is not much emphasis that is put on international law courses. In many universities, international law is not even a compulsory class. You know, I've studied law in Senegal before I went to Geneva, and the course of international law, public international law, was not compulsory. It's only those who would do public law, and we were like minority, that would go into that course, and it was only 1 year. And so the result is that in my promotion, I was the only one who was specialized in international law. So we need to make international law more appealing. And Africa, this is another thing I want to say, is a very fertile ground for international law. I mean, Phoebe mentioned Attorney General offices, Ministry of Foreign Affairs. I agree, but think about the number of international organizations on the continent. Africa is one of the continents with the biggest number of international organizations. You can do international law at the African Union. You can do international law in any of those 8 regional economic communities. You can do international law in any of the how do you call that, monetary union. You can do international law in all these river basin organizations. You can do international law in some of the courts, like the African Court of Human and People's Rights. So it's not true to say that there are no how do you say that, opportunities on the continent. There are plenty of them, but people need to be more aware of them. People need to be more connected to them, and our universities have a role. They have a responsibility in guiding better the young generation to that. Now, how critical it is? Well, it is very critical. It is very critical. You know that, Mamadou. You know some of my my messages. I go in many conferences and I say we need to make sure that Africa or African countries become lawmakers in the international system and not just law takers, rule takers, rule consumers. We need to make sure that our countries are rule makers. What happens quite often, what happens is that we see that in many of our countries, states officials sign treaties, that are not always connected to the reality of the continent, or sign treaties that contain provisions that are not, in our advantage, or sign treaties that are completely disconnected from our developmental needs. You were mentioning investment treaties, I agree, trade treaties, but there's a lot of things that we do that are sometimes just about, subscribing to what is coming from outside, or sometimes about cut and paste. I hate to say that, but when you look, for instance, at the African Continental Free Trade Agreement, which is a great project, which is fantastic, I was always amazed, I was always surprised to see that the dispute settlement system that is there is absolutely, duplicating the WTO dispute settlement system. Yeah. So it's exactly the WTO dispute settlement understanding. Yeah. At the time when the WTO dispute settlement
is paralyzed,
is in crisis, maybe going to disappear. We in Africa, we are building this great project about the AFCFTA, and what do? We take something that has been criticized by the member states here in Geneva. So this is how critical it is. This is how critical it is, making sure that when we engage in lawmaking, when we engage in law interpretation, implementation, that this reflects the needs of the continent, the interest of the continent. And that's why we need to train more and more African international lawyers, people who can really, when they sit in a room with other countries, they can really know how to use international law. It's not about instrumentalizing it, but how to use it, how to adapt it in order to really reflect the needs of the African continent. This is how critical it is.
No, thank you so much, Makane. Of course, I was provoking you and I wanted this reaction to the table. And I have another reaction that I really want also on the table. And it's part of the questions that are being raised. The practice of international law. It's a very male-dominated world. If I was a young lady somewhere in Somalia, what would you tell me? You two who have practiced and taught international law in various continents and world. So here I start with, I want to bring the gender question on the table. And here I give the floor to Phoebe first. Yeah.
So the gender question, I mean, I think you should give it to the men because okay,
but can you take it?
I've had to deal with this question a lot, as you know, because I'm the only candidate. Yeah. I'm the only female candidate from the continent of Africa on the International Law Commission, although in fairness, Africa is not the only worst offender on this, that, other regions haven't done well either. Okay. I'm puzzled because anyone who signed into this, the 143 or so, will know that there are lots of women lawyers in Africa and qualified women lawyers. Yeah. And they're thin on the ground, certainly in the main institutions concerned with the implementation of international law at the international level. And I've been puzzled why this is the case. No one can say because there are no qualified women to nominate or appoint. That's another question. So I don't know. The question is, how do we get from here? I think it's so obvious that this would not be tolerated within most national legal systems today. I mean, in our Kenyan constitution, we have gender parity as a fundamental value. No members of any one body can be of the same gender. I think the figure is 2/3. And I think Africa has some of the most progressive constitutions in terms of, I can't think of any country in Africa that does not in some form embrace gender parity. So how do we get more women? First, I think we need to get more women being genuinely interested in international law and committed to working in international law. It's much harder for people to shut you down if you waive your CV. I mean, I say I've not been elected, but if I say I want to be considered, someone would take me seriously because I would say I have worked in the field. So that's a starting point. The next thing is, I think government should just nominate more women, and women should ask to be nominated. If you're not tapped email your attorney general, your foreign minister, or the Federation of Women Lawyers and tell them, look, I'm a qualified woman lawyer. This position has come up. I want to be considered. So I think that's one way, but that's why my starting point is make sure that you have a strong CV, that you're a good international lawyer, that then you want to be told, but hang on, you just practice domestically in an area of family law. This is an African Union Commission on Human Rights. Why should we put you forward? So make sure that the areas that you're interested in, you have some expertise and that you've attended conferences, what Makane was talking about, so that you're considered seriously, so that you can challenge a decision not to consider you from a position of strength. But I think the debate should probably take place within national governments, within the African Union. I mean, I noticed in the Netherlands where you're based, for instance, I was being told that their national group to the PCA actually decides who gets nominated. So it's a considered decision, you know, who is competent to be nominated either to judicial positions or to the International Law Commission. And that may be one way around it. So these things, they're systemic issues. We need a pool of competent international lawyers so that I can say, well, hang on, these are 15 women, all really good international lawyers. In the election 2027, put them forward for the ILC. That's a starting point. But the other one is, I think we just have, no one gives you power. You have to take it. So the saying goes. I think women need to really ask to be considered seriously.
You are muted, Mama.
Thank you very much for this. Makane, for once, I won't twist the question for you, and I will give it to you as it is.
Thank you. Thank you very much, Mamadou. You know, a few weeks ago, I don't know if it was a few weeks ago or months ago, I saw an email on Ojemid, you know, that email grouping about investment cases and so on, where actually one of the colleagues was informing the mailing list that for the first time in the history, I think, of ICSID, there was an entire tribunal that was only composed of women.
Wow.
So 3 women. And that was like a moment of joy. That was like, I think, 1 or 2 months ago.
Yeah.
And it's crazy. I mean, I was also happy to see that, but it's crazy to actually think that we are in the 21st century, and you know, yeah, people are never surprised when tribunals are only composed of men, and now they are surprised when a tribunal is only composed of women. I think we need to go beyond that. We need to go beyond that. Of course, and I agree with Professor Okowa that gender inclusiveness, gender balance is very important in international law, and I think that, you know, the building of careers in international law should be oriented towards that gender inclusiveness, but the work starts already once again from universities. In universities, in law schools, we need to make sure that, you know, the dissemination of international law is done not only by men, but also by women. So what does it mean? It means that we need to encourage more women to get PhDs in international law, to become professors of international law, so they can also inspire as a women to get into the field. So I believe that this is one way. This is one way of, you know, readjusting or correcting things. But at the end of the day, beyond the gender balance issue, I think that the issue is the issue of diversity. Diversity. You know, we are living in we are evolving in a business where diversity is not yet the rule. I know it's hard for women, but it's also hard, you know, for males like me who come from Africa, or who come from Latin America, or who come from Asia. What we are seeing is that the international law career in many fields is still very much dominated by the Western world, you know, by white male. That's the reality. I don't like to say it like this, but that is another fact of life, that it is a business that is still very much dominated by the Western world. So we need to promote more diversity. But as Professor Okowa was saying, promoting diversity shouldn't only come from the others. We have a responsibility. We, for instance, as Africans, we have a responsibility to promote, more Africans in the international law career. It's very fascinating. It's very surprising to see till today that, when our governments have disputes that they bring before international courts, they would be, represented 100% by non-Africans. So how do you bring the change when those who are supposed to make the change do not make the change? We need to empower our people, the male, the women, etc. We need to empower people. And for me, it is a matter of diversity, making sure that there is more diversity in the field, because once again, international law needs diversity. I think that the crisis of international law in many fields is due to the lack of diversity. Lack of diversity brings also a lack of legitimacy of the system, because at a certain point you have governments that say, oh yeah, but this was decided by people who do not understand me. So diversity is very important for the development of international law, for the effectiveness of international law, for the legitimacy of international law. But I think that things are evolving. And the more, and once again, I agree with my sister Phoebe, the more people will be strong, the more people, publish. We need to publish, we need to publish, we need to be in the conferences. The more we do that, and the more you see things evolving. Mamadou, I was very surprised. 2 weeks ago, Phoebe was also there in Stockholm. There was the conference of the European Society of International Law. Guess what? The concluding panel, which is one of the most prestigious panels for the European Society, as you know, was composed of 2 women and 2 men. And guess what? The 2 men were coming from Africa. I've never seen that in the program of the European Society. It was me and our brother, Professor Direct-Lady.
Wow.
Yeah. So I think this is a signal. This is also a signal that diversity is more needed. And next year, the topic of the conference of the European Society in Utrecht will be about inclusiveness in international law. So there is today a rhetoric for more gender balance, more inclusiveness. But I agree with Professor Okowa. We need also to get that. We need to take that and not wait, inclusiveness to be given to us. We need to make inclusiveness, something normal, something evident.
Yeah. Okay. No, thank you very much. Okay. Yes, Phoebe. Yeah.
Sorry, and I just wanted to echo one thing Makane said, that in a way, we also need more solidarity in supporting each other. Yeah. I have always said it's not an honor, it's not a source of pride to ever say I'm the first African, I'm the only African. It actually is a mark of failure that, either in an institution where I work or I'm the first African to be nominated or the second African woman to be nominated in the commission, or even if elected. In a sense, the key question is how do we build on that, and why, it's not. So I have been very lucky in terms of I've been supported by a lot of men, and I have to confess, since we seem to be doing an indirect way of bashing African men for being chauvinist, my brothers have been entirely, totally supportive of me, whether it's Makane, Dire, Dapo, and I have to say this, in this election, they have been just a phone call away. I've been supported by a lot of them, and they've gone out of the way, despite having their own elections to run, to really make sure that they're doing the legwork for me as well. And I think that's the way it should be, that we need, and maybe this is something the Institute should build on. We all talk about this, but how do we make sure that the next generation are supported when they want to apply for PhDs? How do we make sure that there's a forum like this, where we can have really down-to-earth conversations of how to get onto that LLM program? And if we only manage to get 1 or 2 people, that's a success story. That's progress.
And my mentor is a woman.
Yes. Now we need to move to the second stage of the conversation, which is the tips for building a career in international law. I would like to mix it also with a number of questions that we really got from the chat. And I would like you to address among the tips for building a career in international law. Probably, do you need a bar? The question, do you need to be a qualified lawyer in your domestic jurisdiction? And is it in any way important? That's one question that I want to ask you. The second point that I would like you to take in your answers is, I probably Phoebe already touched upon it, but it is this issue of the divide between specialists and generalists. How specialized should you be, or how generalist should you be? And clearly you should not be a specialist of generalities. So you have to find, that's something I want to take, that if you are possible to take in your questions. There is also another question on legal systems of the world, how they influence international law, civil system, common law system. Perhaps with the Institute would have to organize a special meeting for to tackle this issue. So I would probably stop here, but here I want to give each one of you 7 minutes to come up with your tips for the young generation and for those of us who are trying to strengthen our profile. Thank you very much. Yeah. So let me start with Makane. Yeah.
Okay, thank you. Thank you very much, Mamadou. If you allow me then to jump quickly on the question you asked, and then I will try to summarize what are my tips, my vision of the tips. It's not necessary to have the bar exam in your domestic jurisdiction to engage in a career in international law. It's not necessary. But I'm saying it's not necessary, but I'm not saying that it's not useful. It is, of course, useful, particularly for those of you who would like to engage into international litigation, or to act as adjudicator or as counsel in international litigation. You know, having some experience as an attorney can be very, very, very useful. And actually, I've even seen that in many international organizations, a lot of the lawyers who work there are people who have the bar exam of their countries, who have good experience working in law firms of their countries, etc. So it's not necessary. Personally, I've never done the bar exam, and it didn't prevent me to enjoy the career of an international lawyer. I didn't do it, but I would say if you can do it, because it can only give you more strength and more skills afterwards as an international lawyer. So don't underestimate it. Then the specialization versus, you know, generalist. You know, I always like to tell my students in many universities that one thing I'm very proud of is that I'm among the dying species of general international lawyers, because, you know, it's true that we are living in an era of over specialization. You know, people only do day and night trade law or investment law or human rights law or environmental law, and more and more we are really seeing, you know, less focus on the general international law perspective. I think it's good to have a niche. I think it's actually very important when you build a career at the beginning to have a niche. You should have a niche. My niche at the beginning was international environmental law. So it's important to have a niche, but you need to make sure that that niche will allow you step by step to broaden your horizons in order to really, you know, have a great generalist perspective and overview of international law. If you really want to enjoy this career, it's better to be a generalist. If you are too specialized, you will do every day the same thing. It might be comfortable, but I don't think it's exciting. I find it very exciting today to do law of the sea, tomorrow to do environmental law, then the next day I do investment law, and then another day I do water law. I think it makes the career as an international lawyer very, very exciting. And I think also it makes your work as an international lawyer stronger because you have different perspectives. So for instance, when you advise a government on water law, you need to know environmental law. You need to know investment law. You need to know sometimes even law of the sea because the rivers might be connected to the sea. So it just makes you a stronger international lawyer, and it just makes your client or those who are approaching you being even more convinced that the advice you are giving them is a powerful advice, and they will come back to you because they see that you have a good command of the field. So it's good to start with a niche, a specialization, but then broaden it and make sure to become generalist. And then I think your other question, Mamadou, was with respect to
system of laws.
Yeah, the system of law. It's very interesting. It's very interesting. I come from the civil law tradition, and I think Professor Okowa comes from the common law tradition. And it's very interesting because when you, for instance, when you are involved in those teams of international litigation councils in cases, it's very interesting to see that quite often in those teams you have counsels coming from different civil systems. And if you really want to build communicational bridges, you need to understand the system of the others. If you want also to benefit more from your career as an international lawyer, you need to understand as a system because, sometimes I work for countries that are not of a civil law tradition. And so if you want those countries to come to you, but you need to have an understanding of the other system. So it's one thing to say, my background is civil law, my background is common law. But when you come into the international law arena, you need to transcend. You need to transcend, the dichotomy between those systems and try to understand what is the perspective of common law countries to international law. What is and Professor Okowa was mentioning that the culture. What is the culture of litigation? What is the culture of lawyering? What is the culture regarding human rights law, environmental law? So you need to have a good understanding of all that. Otherwise, your advice would not be that efficient, and the government that is maybe asking you to advise might not be that satisfied. This is what I would say in response to the question. But if I still have 1 or 2 minutes,
go ahead with your tips. Yeah.
My tips. For me, I like very much the title of this webinar, which is the building of a career in international law. For me, when you talk about the building, there is the before the building, the during the building, and the after the building. The before the building, I said it already. Find a niche. Find a niche. Find a powerful internship where you do international law, not just politics, but you do an internship where you see from the inside what is international law, and study international law. You don't improvise it, study it. This is what I call the before building. That's my tips for the before. The during the building, find a mentor. It's very important to have a mentor. It's very important to have somebody who would guide you, who would make you benefit from his or her experience, who would connect you to the network, who would connect you to the club of international law, because that we like it or not, it's a club. So find a mentor, start publishing, start having your name there, even if it is like 1 or 2 pages on a blog, AIIL Talk, I don't know. Start. People see your name step by step, And then during the building, when you get your first shot, when somebody comes to you and give you your first shot, seize the opportunity. It's only 1 shot. If you get 1 shot and you don't seize the opportunity, meaning you show your skills, you won't get the shot. So very important. And last but not least, the after the you know, after all that, make sure that, you know, you participate in conferences. I know it's not always easy to be all over the place, but do your best to be in conferences as much as you can, because this is how you meet with people. This is how people see you. You connect to people. This is also how you start being part of this epistemic community. Be active and organize things. You know, even when you are young students of international law, make sure that in your law school, you organize a little event about international law. You ask your professors to come to speak to you, or, you know, as a professors, there are many of us who are ready to pay a flight ticket and go to a conference, pay our accommodation. If people invite us just to speak, we are ready to do that all the time. So be active and organize things in relation to international law, okay? And then keep on publishing. That's the after building. Keep on publishing, keep on publishing.
Keep on publishing.
Yeah, keep on publishing. It's very important to have your name out there. People think that publications are not important, but they are. That's how you make a name in the career. And if you are a professor already of international law, well, do your best to teach all over the place. Go and teach in Asia, go and teach in Europe, go and teach in Latin America, everywhere. Be there, and then people will come to you. But at the end of the day, the most important tip, my brother, Mamadou, yeah. Passion.
Passion, yeah.
Passion.
Mm-hmm.
Passion.
Yeah.
And believing in yourself. Thank you.
Thank you so much, Makane, for this very passionate speech and for these very practical tips. And now I give the floor to Phoebe. Phoebe, you have the floor.
Yeah, okay. So in one sense, I'm going to differ slightly from Makane, that I think it's very important to grab the opportunity and qualify as a lawyer if you have the chance and when you're starting out. Quite simply, that not everyone succeeds in a career in international law, and even those who succeed, the work can be far in between, and there's a lot of competition for it. So from a purely bread and butter issue, even if I have a flourishing practice doing a lot of international law questions in Nairobi on human rights or advisory work, I don't think, at least in the beginning, there's enough of it to sustain you. So from a very practical matter, I would go and qualify, especially when you're starting out and you still have these options. And the other thing is, sometimes governments are impressed by the fact that you can say, I'm a lawyer. I mean, I'm an advocate of the High Court of Kenya. For what it's worth, I can sort of say, well, you know, I can represent you before a domestic court on a question of international law. So I always say, tell my students that these things are much harder to do once you're older. So if there's a chance when you just finish your undergraduate and there's a window or an opportunity to do it. If you wait, you will get sucked in other things, in academic writing, in a job, it ceases to be that important. But if you're at the stage where you're just thinking, well, I want to do an LLM and you know, shall I do the bar? I would say do it. You just never know when you'd use it as a fallback. And quite crucially, a lot of questions of international law are increasingly applied in domestic courts. You will not have a right of audience unless you're a qualified lawyer in a domestic jurisdiction. The other tip for me is, and again, it relates both to publishing, but also reading, that you really need to read. And again, this may be patronizing because some of the audience are probably people at my level, but again, I've seen from a lot of questions that these are people trying to make a transition to international law, just thinking. And partly because international law operates in a political context. So you need to have a lot of spatial awareness of political systems. You need to talk authoritatively about things. You need to be able to see the problems, the systemic problems in the application of international law. And that just means don't just read the textbook of international law, read quality journals on issues. If the WHO is proposing a treaty on pandemics, what are the elements of these treaties? What are the problems it presents for Africa? So just be knowledgeable. Don't be the person in the room who is perpetually ignorant about issues other than the niche topic on which they know something about. And so, I mean, this is advice I give to my children who are now adults. Just read, you know, subscribe to a journal, log in, read, you know, and we live in an age of the internet. So yeah, if you're thinking of a practical career, I would say if you can, if you're at that stage, or even if you can do it part-time, I would say try and get your practical qualification. Also, it's a fallback, you never know. In terms of, say, being a generalist or being a specialist, I actually think I started from being a generalist. Yeah. And even when I worked on international environmental law, I approached it very much as the application of principles of international law in a particular context. Partly, I think I was taught by Ian Brownlee, who pretty much argued that international law was a system, that you could not just hive it off, salami slice one particular aspect of it and become an expert on human rights or international criminal law without understanding how it works as a system. I think the two can run in parallel, but I would say if you're starting out, which means you're going to do an LLM, do your specialized courses. But if the university, say, offers a course on general principles of international law, do that. Or maintain your generalist understanding. You will be asked a question, a state wants to renege on its treaty obligations, they throw reservations to you. It may be a human rights treaty, or it may be the ICC. You can't just say, well, I'm an expert on international criminal law. You need to know how states can renege on obligations under the multilateral system of treaties and questions of reservations. And that's a very complex body of law, as I realize. You can't just renege or withdraw from a treaty and re-enter it. So my point is, don't be too specialist to forget the general. And I've met international lawyers who actually get worried when you mention reservations, when you mention intervention, when you mention sources. But Professor Makane will tell you, in most of the cases that come before the international court, the question is, was there an agreement? Has the agreement in question fallen into desuetude? They're not, whether it's an environmental question or whether it's a question involving the Whaling Convention, the general questions of international law come into being. When do you have standing? So I would say I would keep both in parallel. And the way to keep it in parallel is first make sure you understand soundly and firmly the methodological questions, the general principles of international law. Even if you leave it on one side, you should be able to pick on your shelf and know immediately what question is arising in this particular context. Is it a question of treaty interpretation? Is it a question of, is it a reservations question? So I would say never lose sight of the general. And in a teaching context, I've always been lucky that I have always insisted on doing some undergraduate teaching of public international law, precisely for the reason that it forces me to read the ICJ jurisprudence to deal with general questions as I go along, even though I now have the option of not doing any of the general questions. Makane mentioned publish. I would agree completely, absolutely, publish. But crucially, again, depending on what stage you are in your career, when you start out, you can afford to be promiscuous, take whatever is offered to you. But actually, once you published a few, you could just start by being selective, because in the end, what matters is one good piece, I don't know, in a very key journal will probably take you much further than 10 pieces in edited collection. So I know when I started out, I think, I went for the British yearbook and stuff like that. And that immediately became a marker of your own ambition, of how serious you are. Because we are in a field where, let's face it, these are markers. So I would say when given the opportunity, go for it, or ask and say, look, I want to publish in the journal. What's the procedure? You might actually be quite encouraged and guided in how to develop it for that niche journal. Because one good piece in a quality journal can actually drive your career a long way. So than lots of little pieces which no one knows. So it depends. Once you get a degree of confidence and perhaps even chance it, the most that will happen is you'll get rejected, but you'll get comments and then take it on to the next best journal. So being selective can actually be quite useful in terms of where that takes your career. Yeah, expose yourself, go to conferences, and here, again, you may want to be very selective. I say this as a woman, and I've had to manage my career alongside raising a family. I'm sure some of you are in that position. And that in itself presents a lot of challenges. You can't just get off and go. You need to think very carefully which trips you can make and how you balance that. Inevitably, even if resources are not an issue, and I'm talking from a position of great privilege teaching in a Western university, resources were hardly an issue, but there was always the question of time, of what would be most useful, and also balancing that with family obligations. So I found I was always so selective, or forced to be selective, just to make sure people don't forget about you, but also that whatever I do at that particular conference would be of a premium and would add value. I would have liked to go to more. I enjoy conferences. It's great for networking. But yeah, I would say if you have other commitments, draw a list, have a matrix. What's the most important conference you should go to? And learn to say no. Because learn to say no will also mean that you will complete the things that you take. I'm only starting to learn to say no, but yeah. I think that's all I had on my list of.
Yeah. Okay. So really, I would like to thank again our two panelists today for taking the time and for sharing with us their insight, their experience, and their very concrete tips for building a career in international law. We are going to close, and that's I was ready actually to close, but I realized that I can still get something out of them. Private companies, we didn't discuss them. Corporations, what is the relevance for practicing international law? We forgot about them because the number of states are limited. The number of international organizations also, but increasingly corporations are areas where job can be found as an international lawyer. So I will just give you a couple of minutes to speak about this, and then I will give the floor to Ambassador Sani, Director of the African Institute of International Law, to conclude.
Do you want me to have a go? Or?
Yes, please go ahead. Yeah.
So I have just one point to make on that. You're absolutely right that corporations increasingly have obligations, especially in the environmental field, the obligation to make sure that they also come to terms with the increased public sensitivity to the importance of environmental values, the increased public sensitivity to the importance of human rights values, labor standards. So there are opportunities for careers in advising corporations, or if you're an in-house lawyer or as a practicing lawyer, those are opportunities that would arise. My husband works as an environmental consultant. He's a biologist by training. And he was telling me that since the pandemic, because the forecast was that they would not be busy. No one knew what the impact of the pandemic was going to be. But he said companies are now have started adapting quite seriously to the obligations imposed on states under the Paris Agreement. And a lot of work they're getting is from companies wanting to know how they can reduce their carbon footprint. So I think there's work in that area. Again, it may be possible that if you're working as an in-house lawyer, you can actually push for the agenda and highlight the need to be environmentally sensitive, the need to have, because it makes good business to have human rights questions right at the front of what the corporation does. It makes good business for corporations to take on board both their obligations under climate change regime or sustainable development goals. And I think there is an opportunity really just to push for it, to drive that agenda, which may not be so obvious to those sitting on the corporate board.
Thank you very much, Makane.
I won't be long on that, Mamadou, because I totally agree with Phoebe. I think we are living in an era of corporate sustainability. We are living in the era of sustainable development goals, and this entails, of course, corporate sustainability. And corporate sustainability requires from multinational corporations, private actors in general, to actually comply better with the rule of international law. And Professor Okowa mentioned human rights law, environmental law, climate change law, et cetera, et cetera. So there cannot be any corporate social responsibility today without, better understanding, better compliance with international law. When you take an initiative like the UN Global Compact, it is about that. The UN Global Compact, it's about, I think 11 principles that are principles of international law, and that enterprises are supposed to comply with. and report on how they are implementing it. So what does it mean? It means that corporations need and will need more and more, specialists of international law to help them with becoming more sustainable. So thank you so much for mentioning it, because I mentioned private actors, individual, when I was talking about counseling in litigation, but definitely to work in those institutions today as an international lawyer is something we need to contemplate. And this is, again, a result of the evolution of the international legal order. Thank you.
So thank you so much, Makane and Phoebe. I'm extremely grateful for your time. And now I would like to give the floor to Ambassador Sani for some concluding remarks. Thank you again.
I don't have much to say besides the fact that we have been highly educated by both Professor Makane and Professor Phoebe and Mahmoud yourself on this occasion. We are very grateful, we are very delighted, and we hope to organize something in the near future of a similar theme. We are very grateful for the fact that Professor Makane and Phoebe went back into many years to bring back the experience and the knowledge they have on this idea. And Mahmoud also, you have gone very far and you did very well on all these occasions. Besides that, we also have a Defe from behind. We thank her for giving us the opportunity to hold this meeting. Thank you very much. We're grateful for being with us this time. All the best.
Thank you. Thank you, Ambassador.
Thank you, Ambassador.
Mahmoud, thank you so much. Bye.
Thank you very much. Bye-bye.
Bye.